Navigating direct investment contracts and agreements. In this video, we will discuss some of the common contracts and agreements you may see as you invest directly into private companies. Our goal with this video is to help you understand the various documents, not to focus on the specific terms you may find or negotiate within each legal agreement, although the relationship between these two topics can become muddied very quickly. As you can imagine, there can be a wide assortment of contracts, as well as terms, depending on a number of factors, including the age and status of the company, the experience of the entrepreneur. You will likely find a significant difference in the contracts presented by sophisticated entrepreneurs compared to those from a novice entrepreneur raising money for the first time. The experience of the investors. Likewise, many sophisticated investors have learned, often the hard way, to demand certain documents before they'll invest, or that some documents are unnecessary for some investments. These same experienced investors may often choose to have relatively simple 1 or 2 page versions of these documents. The experience and skill set of the securities attorney. The typical legal fees for investment rounds in early stage companies range from $5,000 to $10,000. However, the cost of a full assortment of extremely involved and complicated legal documents can exceed $30,000 to $40,000. When looking at legal documents surrounding a direct investment, you need to weigh the cost of the legal fees in relation to the size of your potential investment. For an investment of only $25,000, you have to ask if it is worth that expense. Although a company is usually responsible for paying these fees, often companies seeking outside investments are cash poor. So in effect, your would go towards paying off these bills, not to growing the company. Having said that, what can you usually expect to encounter in a direct investment? Common legal documents for direct investments. Private placement memorandum. Term sheet. Shareholders agreement. While this is far from an exhaustive list at this point, let's look at each of these a little closer. Private placement memorandum. Many times a company will begin their fundraising effort by having an attorney draft a private placement memorandum, PPM. A complete PPM can serve as the only contract or agreement necessary for a direct investment. A complete PPM should include the offering, how many shares a company is selling, what kind of shares they are, and at what price. Information about the company, such as its operations, management, products, and services, and expected use of the investment capital. Company financials, including a company's income statement, balance sheet, and statement of cash flows. Risk factors, anything that can conceivably affect the company and cause the investor to lose their investment. Investor survey, a document you sign to confirm you are or represent an accredited investor. Capitalization table or share register. Either a simple list or detailed spreadsheet showing who currently owns how many shares and how this is expected to change over time. Subscription agreement or stock purchase agreement. We'll talk more about this in a moment, but the subscription agreement is the actual sales contract you sign to purchase the securities as you send in your money. Sometimes a company may not lead with details about the offering. Rather, they may wait to receive what's called a term sheet from the investor. This is the common practice with venture capital firms and other very experienced investors. What is a term sheet? As the name implies, it lists the terms under which the investor will invest. It lists the specific details of the shares the investor is purchasing. How many shares is the investor buying and at what price? Common or preferred stock? What preferences? What rights does the investor buy? Pro rata rights? Participation rights? Preemptive rights? Conversion rights? Board rights? These same terms are often included in PPMs as well. It is just a matter of which side starts the negotiations. Term sheets can be quite long, but some investors favor shorter term sheets that just cover a few key terms. Regardless of length, term sheets are generally not legally binding. Instead, they are used for negotiating the key financial and legal terms of the transaction. Once the investor and company agree on all of the terms are included in the subscription agreement mentioned earlier, which is to be signed by both parties. Subscription agreement, also known as a stock purchase agreement. As just discussed, the subscription agreement includes all of the terms negotiated in the term sheet, along with other key provisions, such as confidentiality. This can include prohibitions about disclosing the terms of the deal and/or confidential information about the company. Non-compete statement, preventing you from investing in companies that compete with the company at hand. Payment terms, how you send in your money by check or wire transfer. Transfer of shares, how you will receive the shares. Any risk factors not included in the PPM. To recap, in any direct investment, you should see and sign a contract detailing what you are buying and for how much, as well as a statement about the risks involved with a particular investment. This can be included in a PPM or subscription agreement, which can almost be used interchangeably or created independently. Other agreements you may be asked to review or sign during the process of investing directly into a company include shareholders agreement or stockholders agreement. While the name is similar to the subscription agreement or agreement, it is a distinctly different document. The shareholders agreement usually covers potential issues between shareholders, such as a process for selling or transferring shares. Investors' right agreements. Similar to the shareholders agreement, the investors' right agreement focuses on potential issues should the company go public. The substance of the IRA may be included in the PPM or purchase agreement. Amended and restated certification of incorporation, COI. Sometimes a company's original COI is insufficient or inadequate for the sale of new shares. To allow for new shareholders, board members, or terms negotiated in this round, the company will need to submit an updated certificate of incorporation to the Secretary of State office in the state or states it is registered in. Options agreement. Options are usually granted to employees of the company, but may affect your ultimate percentage ownership of the company. The options agreement may include details such as strike prices, vesting schedules, and other terms that govern the granting and exercising of stock options. Voting trust. When there are several incoming investors, it might be easier and cleaner for them to form a voting trust that acts as a single investor in the eyes of the company. Officer indemnification. If you take a board seat, you may ask for a document protecting you from liability resulting from actions of the company. You may also request to see a copy of the company's directors and officers' D&O insurance policy. The exact terminology on these documents may vary company to company, often based on geography, industry, or even law firm. And again, which documents you see and in what form will also vary based on the specifics of the deal. One final note. Everything we have discussed so far relates to equity investments. If the company is offering a debt arrangement or you are offering a loan, a single document called a promissory note may suffice. This note, or debenture, is a legal promise by the company to pay back the lender. Thus, the document details the principal amount owed, the interest rates, and maturity dates. The simplicity and relatively low cost to create a promissory note is one reason investors and companies choose to engage in a debt arrangement instead of a full-fledged equity investment. Depending on the size and stage of the company, as well as a number of other factors, a promissory note may be a viable option. Whether you make an equity or investment or loan, remember you will need to sign at least one legal contract. We cannot emphasize enough how important it is to have your own qualified legal counsel review any contracts before signing.